is bankrupt. We don't have to pay anything.
Major 90% of the assets are totally protected.
Right?
Yeah.
I'm not sure, I mean, it makes no sense that you could isolate your assets that way and not have the liability follow.
That was the thesis of the story.
Yes. I didn't hear the full story, but the teaser was very interesting.
So if a corporation can do that, and corporations are people, then why can't individuals do that same thing?
Yeah, and part of what they said to tease the piece was, it just puts the federal bankruptcy law then becomes a shambles. It's a sham. It doesn't work. Good point. And no one has to repay student loans.
We all set?
Yes.
Okay.
Good morning, everyone. Apologize for the delayed start. We had quorum issues and we've had multiple IT issues, but I believe we're all set at this point. Welcome to the October 20th, 2022 LCAR meeting. And before we get into the agenda, I'd like to go around the table and do introductions.
Hi, I'm Carol Odie, and I represent the far new north end of Burlington. I'm on the House Ways and Means Committee.
My name's Christopher Bray. I live in Bristol and I represent the Addison Senate District.
And I'm Representative Mark Kigley, and I live in Lowell, and I represent the Orleans-Lamoille District.
Representative Seth Blumgartz. I live in Manchester, and I represent the towns of Arlington, Manchester, Sandgate, and a bit of Sunderland.
Good morning, Representative Trevor Squirrel, representing Jericho and Underhill.
Anthea Dexter Cooper, Office Legislative Counsel.
Senator Jenny Lyons, representing Chittenden County on Zoom.
I didn't mean to cut you out of the action there, Senator Lyons.
It's okay.
The first agenda item are the minutes from October 6th.
Make a motion, we approve those minutes of October 6th.
Second.
Okay. Discussion? Favor say aye.
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 Aye. Ayes? Okay, thanks. Okay, first item, first rule, 22P11, Department of Health Vital Records Rule. I believe David Englander will be speaking to the rule. David, welcome.
Oh, no.
No.
No,
It's his fault.
Okay.
user error. Good morning. My name is David Englander. I'm the Senior Policy and Legal Advisor to the Department of Health. Briefly to the conversation before the meeting began with regard to corporate assets, one of the more fun phrases you learn in law school is piercing the corporate veil, which I urge you to Google following your meeting if you have some spare time and or you're having trouble falling asleep this evening. So the department comes before you with the Vital Records Rule, an emendation of the Vital Records Rule. This rulemaking follows the passage of Act 88 of 2022, which allowed the Department of Health, or required the Department of Health, to amend the Vital Records Rule to allow Vermonters who have Vermont birth certificates to amend their birth certificates, the gender markers on their birth certificates, either from a binary, from male to female, female to male, or to a non-gender, to a third gender, in a simple and easy fashion. This follows the previous regime, which required both legal and medical intervention for a person to change their gender, and this rulemaking implements the act that required a simple and clear process. The rule in its vast substance is currently in place. It was installed it was adopted as an emergency rule on July 1, and has been in place since then. The Department of Health did hold a public meeting. We did receive one set of public comments. The majority of the comments that the department adopted into the rule, trying to make the rule somewhat simpler as much as possible. The affidavit form is a one-page document that a person signs to to change their gender marker. This process mirrors what's going on in many other states, such as New Jersey, Illinois, California, and Maine. At this point, I would welcome your questions.
Representative Higley.
Mr. Chair, thank you. Thank you, Mr. Englander. I was the one who, when this came before us before, had a question concerning the definition of non-binary. And I'd like to appreciate Anthea for explaining to me, and it sounds like the same definition is in there. There was just some concerns over wording, in particular, the last word on that whole definition, talking about or otherwise unspecified by the person. And again, I think Anthea did a good job of explaining why unspecified was used and not specified, and I appreciate that, and I don't have an issue. Thank you.
Senator Bray.
Thank you, Mr. Chair. I just wanted to thank the department for steady, timely engagement on the issue over the last year or so to help strategize on a clear, effective solution and then to bring forward the rule. Appreciate that. And unless there's another question, then I would like to move approval of Rule 22P11.
We have a motion to approve Rule 22P11 from Senator Bray. Any more discussion?
There was the one change to the statutory authority section.
So we want to amend that motion?
I mean, obviously, if Senator Bray wants to.
Yes, yes, please, thank you. I didn't have my note in front of me to make sure I had the last. Okay. All right, so I'd like to amend the motion so that it would be approval of Rule P22, the Vital Records Rule, with Section 1 modified to read, this rule is adopted pursuant to 18 VSA Sections 5000E8 and F and 5112B. Wonder I didn't remember exactly.
Okay. Any discussion?
I was going to second it.
All those in favor, please say aye.
Aye.
Opposed? Okay, thank you very much. Thank you, Mr. Englander. Okay, now we have 22E15, Emergency Rule, Department of Children and Families, Transitional Housing Program Emergency Rule. And speaking for the department is Ms. Moreau. Is that correct?
Great.
Okay. Floor is yours.
Thank you. Good morning. I'm Heidi Moreau, a DCF policy advisor. The Transitional Housing Program was initially established via emergency rule on March 31st. It's funded through the Federal Emergency Rental Assistance Program, and it provides financial assistance to eligible households in the form of direct monthly payments to motel and hotel owners who've executed an occupancy agreement with an eligible household. In the fiscal year 2023 Big Bill, the legislature authorized DCF to adopt a second emergency rule in order to continue the program upon the expiration of the first emergency rule, which expired on September 28th. And this second emergency rule took effect that same day. This second emergency rule is essentially the same as the first one. The only differences are that DCF added language permitting the use of state funding if available to continue the program. A deadline of October 1st was set for new applications to ensure that households currently participating in the program could continue to receive assistance with the remaining funding left. A cap of $5,250 was set on monthly rental assistance, and a cap of $3,300 was set on security deposits. This security deposit cap was already established via procedure during the first emergency rule, but it was included in the second emergency rule. And I'm happy to take any questions the committee has.
Okay, not seeing anything. I do have some letters from committee's jurisdiction that I would like to share.
Sorry.
Okay. We had 3 committee chairs, 2 House committees, one, I'll speak to the 2 different documents I have. One is from the chair of House General Housing and Military Affairs Committee, indicating that he feels this particular rulemaking is contrary to legislative intent. There's no note attached to that as to explanation. But in my conversation with him, he did reference language in the FY23 budget in section E325 that indicates that the second rulemaking is not supposed to be substantial. It needs to be substantially similar to the first rulemaking, which was 22 E07. And the fact that we're terminating the program and making changes, that he feels that doesn't meet legislative intent. So that's that chair's response to that. The other one is a memo from the chair of Senate Committee on Health and Welfare and the chair of House Committee on Human Services. And I'll just read this if some of you don't have this document. Documents probably. Have you seen this document?
We've seen it. I've seen it.
All right, great.
But
Multiple committees considered the transitional housing program during the FY22 budget adjustment process and the FY23 budget process. Upon reviewing 22E15, the emergency rule pertaining to the transitional housing program, the chairs of the Senate Committee on Health and Welfare and the House Committee on Human Services believe that the rule does not meet legislative intent pursuant to 3 VSA section 842B2. Specifically, the policy committee chair is subject to the Department of Children and Families addition of an October 1, 2022 deadline for receipt of new applications. By including this deadline, the department has in effect limited the program to those recipients already receiving services and omits those individuals who may still need services at a future date, which was never contemplated by the policy committees. So I thought I would put that on the record, and I see that Senator Lyons has her hand up. Senator Lyons?
Yeah, thank you, Chair Squirrel. I was just going to indicate that that letter had been sent. Our committee does review and look at housing of multiple types, including transitional housing. I did not receive the sign off for this, but I felt compelled to add our concerns about this. So I think we've said enough. I'm thinking that perhaps time should be given for a review of this through joint fiscal, if that's possible, rather than vote today. I can't vote today anyway, but I think that the rule has substantial questions attached to it that we should try to set it aside today.
Thank you, Senator. Representative
question
Baumgart?
for Anthea, how much time do we have before we have to act?
So this is an emergency rule, so that's not that same 45 window, or it's deemed to be approved. So you certainly could postpone and take it up at your next meeting. But that being said, the rule is already in effect because it's an emergency rule. It went into effect as soon as it was filed, or as soon as it was adopted.
Senator Higley.
Thank you, Mr. Chair. If I could ask Ms. Murrow, in regards to, I know you had talked about limited funds and that October 1st deadline. What would that mean if that deadline was extended? And maybe a question for Senator Lyons as well is, what are we talking about for an increase in that deadline?
I don't have the calculations on how quickly we would essentially burn through those funds if it was opened up or cut off at a date beyond October 1st. But that's something the department can certainly look into.
Thank you.
I'll add a comment. I have been in contact, of course, with the agency, and there is state money apparently available to continue the program. And then the question would be taken to joint fiscal, more of a policy committee for any decision making about how to proceed. Right now, the rule is contrary to legislative intent by having the date October 1 in the rule.
Senator Bray.
A question for Ms. Moreau. So thanks for your help. And I want to understand, can you explain a little about the thinking in the inclusion of that cutoff date? Is it purely a financial analysis on the administration's part, or what it deems as you have sufficient money now only if that date is included? Can you just walk through the thinking to add that vision?
In order to ensure, in order to give the greatest likelihood that all participants that are currently in the program could continue to receive funding through the end of March, it's my understanding that the October 1 cutoff date was necessary to ensure that everyone that's currently in the program could remain stably housed until the end of the program in March 2023.
Thank you. And if I may, to follow up with council. So the inclusion of the date seems like, in essence, either a policy decision or a decision around how to allocate funds. And those decisions, my understanding, has always belonged to the legislative branch. So I'm looking for a little guidance in terms of your sense of the appropriateness of adding that date to the rule requested through legislation.
I'm going to potentially look to Katie, who knows more of the language that made it into the legislation that directed this to be done through emergency rulemaking. I do not think it included in it language surrounding how long the program needed to last or any parameters around that specifically, but there were appropriations for this. There was the use of federal money for it. This being an emergency rule, by its very nature, it's going to go away after 180 days. So this is, I would say, more of an administration decision within it. But even though it is an administrative decision within it that is left to the adopting agency, it could still be contrary to legislative intent and grounds for LCAR to object to the rule. And then just as a reminder, even if LCAR objects to the rule, it doesn't change the rule, it doesn't invalidate the rule, it just shifts the burden if there's that legal challenge. That being said, I think you could be in a world where it is inconsistent with legislative intent, but it was within the agency's authority in adopting the rule to do what they did.
Thank you.
I don't know.
Ms. McGlynn, do you want to add anything, or you're okay?
I think Anthea really covered it, but the legislation itself didn't specify one way or the other an end date for a particular program. It didn't specify whether there would be a cutoff deadline for the program. So the legislation was silent on that point.
Representative Odie.
For people who need help, is there a way to track who they are? How would we know that people need help after October 1st?
The General Assistance Temporary Housing Program is still in operation, and at some point the agency will be announcing the adverse weather condition policy, which, as you may be familiar with, expands the temporary housing eligibility criteria and opens it up during those cold weather months, so that more people may be housed. So people who are not eligible for the transitional housing program, there are other housing options for them.
Would we be, who would have access to knowing who's still left behind and how many people?
Yeah, I'm not sure what data the department collects on that, but we could look into that.
Thank you.
Senator Lyons and then Senator Bray.
Thank you for letting me speak. The issue around the date, I think, is critical to the decision making that we have. The question that I asked yesterday, and I'll ask again because I think Anthea may be able to help with that. This is in a rule, and obviously there are always procedural guidelines for any distribution of funds once we appropriate them. So my question is, could the agency have just gone ahead with the work and then at the cutoff of October 1st said there are no more funds? Is that also, and maybe Katie can help me with this as well, would that also be contrary to legislative intent? So if it, rather than rules, procedural guidelines, administrative guidelines.
So it's going to be hard for either Katie or me to say what the legislative intent is or what is or is not contrary to legislative intent because we are not the legislators here. I will say that the language in the Budget Adjustment Act and then the Big Bill directed the agency to adopt rules to cover this program, and that is what they did, and this date was included in the rule. And by being in the rule, it has the full force and effect of law in a way that a procedure or a guideline or a policy doesn't. Hope that helps without sort of towing the territory of saying what the legislature's intent was.
Senator Bray.
Thank you. A follow-up question, catching up on more history. Ms. Moreau, did the administration come back to, for instance, the Joint Fiscal Committee and point out how that you're looking at the budget? Here was a proposal to add this, a cutoff date in order to manage the program. Keep it adequately funded for what you were anticipating through next spring? Or do you consider asking for a further appropriation or discretion to spend money in a different way, et cetera? I'm just wondering if you explored the path of not including a cutoff date, but requesting more funds so that you could, with reasonable administrative confidence, continue without the date.
To my knowledge, there were not discussions around requesting additional funds. I can say that the rule with the cutoff date included was presented to the Joint Fiscal Committee at their September meeting.
Okay. Thank you.
If I may maybe add a little context to this discussion. I have been in contact, and folks have been in contact with me or some of the stakeholders out there working with individuals that are impacted by these changes. And they really weren't included in the conversation around these changes to the program. I appreciate that the funding is the funding. And you can go back and look at language in the FY22 budget and the FY22 Budget Adjustment Act and speaks to the extent that funds exist. So that's out there. I get that. The legislature was not notified of these changes and to the last minute, even though the administration knew they had a problem many months before that. So I think that sort of adds to the context of this conversation. Now, having said that, one other thing, in one of the organizations I had spoke to, that if they had been brought into the conversation when the problem was recognized, but they could have contributed maybe some training using that money and extending it or making some changes to program. Having said that, I know that the chairs of Senate Appropriations and House Appropriations have met with the administration, and we're talking about some of the programmatic and financial implications of the change that's gone into effect. I know they've reviewed a lot of the records around the program to get a better handle on the burn rate and what might happen. So there's a sense in my last conversation with those folks that administration needed a couple of weeks to sort of fine tune their thoughts about the programmatic and financial implications of where we are currently. I know new money's been found, but I think that'll have to go through Joint Fiscal Committee. I just want to put that out there so people have a sense of that conversation that's going on. So, thank you. Senator Bray.
Pending any further committee discussion, I'm looking at the 45-day review end date, and it's
Senator, it doesn't matter because it's an emergency rule.
Oh, right. Thank you. Just want to make sure we weren't going to run afoul of any procedural deadline to postpone action so that people could continue to discuss and see if we might find a better path forward than simply approving or disapproving the rule as currently offered.
Okay.
So I would propose postponing action until our next LCAR.
Okay, we have a motion from Senator Bray to postpone action on Rule 22E15 until our next meeting, which I believe is in 2 weeks on November 3rd. Any additional discussion?
I would just comment that I think that that's the wise path. This is actually, inserting the October 1st deadline is actually a substantial change from consistent with the current program. And we need time to explore that. And I think all of us around the table, and I'm sure the administration as well, all of us are worried about the implication for people who filed a day late.
Sure.
And that, I don't think that's what the legislature intended. And I think the idea would be obviously to see if more money can be found. There's ways to keep this going. And then in any event, we'll have the Budget Adjustment Act early in the session. And so if we can keep that, what the administration can do, what we all can do together in the meantime. And then that's, I think, keeping this alive and not cutting people off arbitrarily from the program now when we could end up with some people in serious trouble is so giving us the couple weeks to explore this more, and the administration a couple weeks to explore this more is really pretty clearly the right path.
Okay. Thank you. Any more discussion? All those in favor of the motion, please say aye.
Aye.
Those opposed? Thank you. Thank you, Ms. Moreau.
Thank you.
Okay, the next rule is 22P13, Vermont Public Utility Commission, Rule 4.600, definition of electric transition facility, and 30 VSA, Section 248.
Good morning. My name is Micah Howe. I'm a staff attorney at the Public Utility Commission. With me is Mary Jo Frolevsky, who is a utilities analyst at the Public Utility Commission. We are presenting a new rule for the commission under 30 VSA Section 248. The commission grants certificates of public good to electric transmission facilities. Electric transmission facility is a term, one of several that appear in that statute and has never been defined. Back in 1972, the commission defined that term in General Order 51. Since that time, transmission systems and more importantly, distribution systems have evolved in voltage, and that definition has become guess, out of date. And so we have issued orders every year since 1972, updating that definition. And this rule finally will provide a definition for electric transmission facility and end that annual order process. We are open to any questions that you have.
Any questions for the witnesses? Senator Bray.
Thank you. Good morning. Sorry, I left my marked up copy at home. So just in terms of conversations you had with the distribution utilities or other interested parties, is there any substantial amendment or that you felt was necessary to modernize the rules so it covers all the kinds of activities that are taking place in current systems? So that's my question.
There were some additions, just kind of fine tuning to reflect the distribution systems that are in place today. We had a workshop and several rounds of comments with the distribution utilities on these issues, but largely ended up reflecting what has been in place historically for decades at this point.
Okay. Thank you.
Any other questions?
A motion, Mr. Chair? Make a motion, we accept 22P13, which is the Vermont Public Utilities Commission Rule 4.60 definition of electric transmission facilities.
Yeah, we have a motion from Representative Higley to approve 22P13. Any
Second.
discussion? Secondary. Any discussion? All those in favor say aye.
Aye.
Opposed? Thank you very much.
Thank you.
Okay, next up is Rule 22P19, Department of Public Safety 2021 Vermont Plumbing Rules. And is it Mr. Gero?
You're muted.
You're muted. Can't hear you.
Still muted.
It seemed that your microphone had turned on, but no audio is coming through, just so you know.
Does he have headphones plugged in?
Do you have headphones plugged in?
Just by way of reassurance, you're not the first person this has happened to.
Give Mr. Gero a little bit of time.
Yeah, this is like me going to get my son.
As good as I can. It's not you here, so.
Gremlins are at work everywhere.
Now they're frozen. Oh, no, they-
Can you hear me now?
Yeah.
Good to go.
Great. Thank you, Alex.
Okay. I'm just down the hall.
So you can see computers are not my strong point, I guess. So good morning. I'm Gerald Garrow. I'm the Chief Plumbing Inspector and Chairman of the Vermont State Plumbing Examining Board. I'm here representing Division of Fire Safety, looking for the approval of the 2021 Vermont Plumbing Rules. We've been working on the rules for approximately 2 years, and we feel that the 2021 rules will bring the plumbing industry up in the newest and latest of the plumbing requirements. We've made slight changes and modifications to the 2021 IPC code in the rules to fit Vermont, mainly the climate freezing issues. In the changes and modifications, we feel that we have not raised any issues to cost or any cost projections at any cost, whether we made changes or the changes to the IPC. We feel that they're minor changes, and we feel that it did not raise any issues with any type of cost. We feel that a couple of our classifications within the rules were just there for clarity, and you have obviously a copy there, and so we tried to do those for clarity. And we received only one comment, and we fixed the changes on the comment during the hearing period. Thank you.
Any questions? Senator Bray.
Thanks, Mr. Chair. So this is, this isn't a question about the rule per se, but a practical question to you based on what I've been hearing from some plumbers in the field. The suggestion they offered to me was that the current rules, as they understand them, only allow them to have a single master plumber, I guess it is, to have a single apprentice at a time. And that it takes approximately 4 years for that apprentice to sort of graduate the program and become certified. And that this is a real bottleneck for them to grow their own business. And, and then the state overall has an interest in workforce development. So my question is that a correct interpretation of the rules? And secondly, where would a legislator appropriately go for reconsideration so that one master plumber might supervise more than one apprentice? Is that a question of rules, or is that a statutory issue?
So I believe it's not in the rules. I think it would be something statutorial that would have to be added, because obviously the rules are what the statutory says. We use the apprenticeship Department of Labor. We kind of use their, when they sign up a person, for the apprenticeship. So I guess we don't really have a lot of ground on that. And so we're telling them that they should, have a master plumber 1-to-1 or a journeyman 1-to-1. As inspectors, not to get long-winded here, but as inspectors, we just want to make sure that an apprentice is supervised, because that's what our rules say. They have to be directly supervised. Right. So when you have 3 or 4 apprentices and one master, chances are they're not going to be directly supervised because they're in different parts of the building. So that's as far as enforcement goes, we usually just try to say this is what we feel should be 1-to-1 because it says direct supervision. And we feel if you have 4 or 5 guys, that probably won't happen because the apprenticeship only signs up on a 1-to-1 basis, but they do make exceptions for some of the bigger companies. If you have, so that's up to Department of Labor on that. So I'm not sure if I answered your question, but it's not in the rules. It's not in statute. And if we wanted to do that, I think it would have to be statutorial.
Okay, great. Thank you for the help. Now I'll know how to chase this down a little further. Thanks. Okay.
Representative Higley.
Mr. Chair, thank you. Senator Bray and I had a little conversation this morning. Sounds like we've talked to our plumbers recently. This is a similar question, I guess, Mr. Garrow, in regards to a plumber who had told me that he may be certified in a particular, I don't know if it was a boiler unit or heating unit for a residential unit, but once he went to a multi-family unit, he could not work on it. Again, is that something through rules or a change in where would we work towards getting that change made?
Okay, so we have licensed plumbers, master journeyman, P1, P2, P3. And so if you are a licensed plumber in those areas, P3 is water treatment, P2 is if you're going to do just hydronic heating and hot water heaters, and a journeyman works under not direct supervision of a master, but he can't work alone, technically alone. And then the master, you do not need any of the specialty licenses. Now, I think what I'm hearing you is there is also certifications. So a certification program is not a license, and the certification programs are oil and gas. And in this particular instance, and the certification program allows you to do certain things. So the certification for oil would be for oil burners and oil tanks and what they call the breaching on the exhaust of the equipment. And the same thing for gas, it would be gas tanks, gas hookups, and the actual piping of the gas equipment. The boiler itself or the water heater itself, the hydronics of the boiler are a license, and the certification is outside that. So I'm not sure. I think what you're asking, maybe it was somebody that works for an oil company or that has a certification, and that just allows them to do what their certification says. And if they're installing a boiler, which means the hydronics is the circulators, all the hydronic heating portion of that, you have to be a licensed plumber, which is a P2. So I'm not sure if I answered your question.
Well, again, just a little follow-up. I'm not real clear on the specifics, but again, this is a licensed plumber. And my understanding that he can work on and service a particular unit in a residential unit, but once it's a multi-residential unit, he's not allowed to. So that sounds a little different than what you've described, but.
Not to interrupt you, sorry about that, but when we say licensed person, there is no stipulations. If we have jurisdiction, so anything that's a public building or anything that's tied to city water and sewer, you're allowed to do. We don't have any stipulations on BTUs or commercial versus residential. So I'm not sure if I'm hearing you right. There is no restriction.
Hey, thank you. I'll let him know.
Oh, Senator Lyons.
A quick question as you're talking, and I'm thinking about some of the work that we did last session on in this area. How much of the licensure and certification takes place in your area, public safety, as compared with the Secretary of State's Office of Professional Regulation? Is any of this in OPR? And so I'm looking at the relationship between what happens there, if at all, and with your department and agency.
So our licensing and our certifications, oil and gas, are done through our Department of
Okay.
Safety. Yeah.
So everything that we're talking about in terms of plumbing is also done in your
Yes.
area?
Yes.
Okay.
Yeah.
Thank you.
And then our jurisdictions within the building, 10 feet outside in. Yes.
Representative Bonkas.
Just really out of curiosity, you said that you only got one comment. Was there outreach? And my guess is that a lot of the people who are involved in the industry are not as likely to have gone through and read in detail and then filed a comment. And I'm just wondering if there was outreach or is there sort of constant outreach to get a sense of the things, the issues that
Well,
the people involved in the industry may see as impediments or not necessary or whatever. Do you have that kind of line of communication open constantly and then as it related to this rule?
I believe we do through our meetings that we've had. We've had meetings, architects, engineers, not on a regular basis, but to certain ones for feed. We have an engineer on our plumbing board. We have Vermont Plumbing Association involved with our talks. We have the union plumbers involved. So I think we have reach within the people that we deal with every day. And Bob Sponable's not on right now, but he's our person from fire safety, and he's the one that mailed out all the stuff to, and I believe all the architects and engineers were on that list that the rules about the public hearing.
Okay,
I believe so.
That's a good answer. Thank you.
Any other questions? Senator Bray.
If we're ready for a motion, I would propose that we approve Rule 21 P19, Department of Public Safety 2021 Vermont Plumbing Rules.
We have a motion from Senator Bray to approve Rule 22 P19. Any additional discussion? All those in favor say aye.
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 Those opposed? Nay? Okay, thank you.
Thank you very much. I do have one question. What would be the effective date of the?
Yeah, so
30 days?
rules are effective at the earliest 15 days after they're adopted. And
Okay.
the paperwork that you need to fill out with the Secretary of State, there'll be a place to fill in that line. It could be later than 15 days if you wanted it to be at the start of a month or, something, January 1, whatever.
Okay, great. Thank you very much.
Thank you.
Thank you.
Okay, the next rule is 22P10, Vermont Public Utility Commission Rule 2.0, Rules of Practice. I have a Kyle Marinello, and must be one other individual here.
Yeah, good morning. I'm Kyle. I'm Landis Marinello, General Counsel at the Public Utility Commission, here with John Cotter, Deputy General Counsel at our commission.
All yours.
All right, thanks. So this has been a long process to get our rules of procedure updated. It started over 2 years ago with a pre-rulemaking process where we were looking at our rules of procedure, and this was driven mostly by two things. One is Act 174 of 2016 created a working group to look at how to facilitate public participation in our proceedings. And one of the things that came up was our rules of procedure and how to simplify and clarify those. And then the second thing driving this rewrite of our rules is that it's been many decades since most of these rules were put into place, and we've never really done a holistic look at them. And a lot of things have changed in terms of the practice and procedure. I'll just mention a couple of things. The biggest change is the switch over to electronic filing. So we used to do everything on paper. Since January 1, 2017, almost everything's been done electronically through EPUC. We've also had a number of changes in recent years during the pandemic with just switching to remote proceedings, doing service of process by email when the parties agree to that, not requiring notarizations when in-person contact was discouraged. And so when we were looking at this, we saw a need to really do a wholesale rewrite of our rules of procedure. We did a pre-rulemaking process that involved communicating with around 380 regular stakeholders who participate in our proceedings, getting comments, 4 rounds of comments, holding 2 rounds of workshops with the stakeholders who showed up to participate in those proceedings. And then working with commission staff, also using our in-house expertise on the rules of procedure and practice to figure out how to update the rules. And we ended up with this document, which is significantly longer than the current Rule 2. However, in reality, it's about half the length of the rules that currently apply. And the reason is that Rule 2 has taken 3 documents and put them in one. So one is the existing Rule 2 is still there. 2 is our rules of electronic practice and procedure. The legislature authorized us to make rules of procedure by order, and we did that when we switched to electronic filing. But now we're codifying those into Rule 2. And then the third document is the entirety of the Vermont Rules of Civil Procedure, which is a very lengthy document that lawyers like John and I are very familiar with from litigation. But if you're a non-lawyer, many of those rules of procedure are not well known. We heard from stakeholders that they're not familiar with them. They'll come up in proceedings and they don't even have a document to refer to see what rules being cited. So that was the biggest change, was actually folding those rules, the relevant ones, directly into our rules of procedure. So now every participant can come to our hearings and have one document that includes all the rules of practice and procedure.
Representative Higley.
Thank you, Mr. Chair. This is an email that I think we all got a number of weeks ago, but it was a question from Annette Smith from VCE. Maybe you've already answered this, but I'll just read her question if I could. Currently, it is possible for attorneys to put in a limited notice of appearance for PUC proceedings. Often this is done specifically for evidentiary hearings. Will this rule update continue to allow this practice? She had asked one of us to ask that question.
Okay. I don't believe anything in here would change that. What we've done in terms of allowing notice, notice of appearance from attorneys, we've simplified the process in here in that a lot of it happens automatically in EPUC. And we've also made it clear that the swapping out of attorneys is a much more streamlined process. It's not uncommon for an attorney from one firm to leave and a new attorney from that same firm is now representing the same client, and we've simplified that process. In terms of a limited notice of appearance, I do think that would require a motion to be filed along with the notice of appearance to explain that it was being done in a limited capacity. But I don't see anything in our rules here that would change how we would handle that type of limited appearance if someone requested to do that. Does that sound right to you, John?
Yeah, I think that sounds right. And I'm going to try to telegraph Ms. Smith a bit, just based upon some of the experience I've had, is what you sometimes see is in a contested case, and using that both formally in the context of the idea of what a contested case is, but also one that happens to be pretty hotly contested, which, happens from time to time before the commission. Sometimes what you'll see is neighbors to a proposed project, for example, will intervene and become parties. And as the case progresses and becomes a little bit more complex and the hearings are approaching, they may decide later in the process that, we probably should have an attorney representing us at the hearing. And so sometimes you see a notice of appearance late in the case. And in that instance, I can't think of any time where the commission has ever said this is a problem. And as Mr. Landis Marinello said, there's nothing in this rule that would change that. So I can't imagine that being a problem.
Thanks for that. Appreciate it.
Senator Bray.
Thank you, Mr. Chair. Good to see you. And I wanted to start by thanking the commission for working on bringing into a single document all the information that someone needs in order to be able to participate. It's sort of a user-friendly thing, I think, to do to make it easier to work with the rule. So, and in keeping with other changes in the last 5 years, like EPUC and stuff like that. There was a section of the rule as originally proposed that was of concern, a couple of sentences, so I'll just read them. So if someone's following, if I may.
Yes.
And in the original rule as proposed, it said, additionally, whenever the rules of civil procedure are amended or updated through an administrative order of the Vermont Supreme Court or otherwise, or at any other time for good cause, the commission may, in its discretion and without formal rulemaking, incorporate any amended or new provisions of the Vermont Rules of Procedure into these rules, or make any other changes to these rules by commission order. Unless there's a need to act immediately, the commission will issue a proposed order for comment from stakeholders before the commission issues a final order incorporating any amended or new provisions. So it was really the latter part of that that I think was of concern to some legislators, including myself, which is why I hadn't signed off as a chair of a committee of jurisdiction. But it's now my understanding that you're proposing to withdraw those provisions from the rule. And I just thought, one, if you could explain a little, and two, make sure that we're exactly on the same page about withdrawing that language, and so that everyone understands why we're making a change to the rules originally presented.
Sure. Yeah, I'm happy to answer that. And thanks for flagging it. This is a change that we are proposing to delete that language. And the reason we put that language in is that we realized we created a bit of a problem when we made the switch of incorporating the rules of civil procedure directly into these rules, which is under the current Rule 2, we apply the Vermont Rules of Civil Procedure as adopted back in 1982 or any amendments to it. And whenever amendments are made, which happens quite regularly by the Vermont Supreme Court, those amended rules of civil procedure automatically apply to our proceedings. And when we were now taking the rules and putting them into our own document, we were losing that. And so we wanted to be able to make the same updates the Vermont Supreme Court was making and not fall behind in changes that they were making, because generally the changes the Vermont Supreme Court makes make a lot of sense. And so that was where that language came from, was we had a concern about how we could keep up with the Vermont Supreme Court if we were regularly going through the full rulemaking process, which is a lengthy process and an expensive process too for a small agency like ours, just the cost of doing those rulemakings and publishing notification, everything. And we also we are situated differently from other state agencies in that we're quasi-judicial, and as I understand, I believe we're the only agency that is granted by statute the powers of a court of record. And so we did see that as allowing us to make updates to our rules of procedure, not to our substantive rules, but our rules of procedure, the same way as the Vermont Supreme Court does when they update their rules. And there's obviously checks on that, like the legislature could always pull authority back, could change any rule we made. Same as the legislature can override a rule that the Vermont Supreme Court makes through passing a statute that changes that. And so that was where we landed. We did get feedback from Legislative Council about concerns of doing that through the rulemaking process. We took that feedback seriously, and we did decide it made sense to take those sentences out of the rule. Senator Bray, I will give you a heads up if you have not heard that we probably will want to address this through a statutory change. But we think that would be the route to go rather than doing it in the rule itself.
Okay, great. And so thank you for that. So get returned to my post. I'll look forward to seeing you again in a few months. And then just practically speaking, without that provision in there, how do you foresee keeping yourself in sync with the changing rules of civil procedure?
Yeah, well, we won't be for periods of time, but I think what our plan would be is one, to look for a statutory change that could allow us to make these changes and with a process where anyone could challenge if they thought we weren't adopting what the Vermont Supreme Court did. And if we don't get that, I think we would set up an internal schedule where maybe every year we would look at all of the updates the Vermont Supreme Court made, and we would go through a formal rulemaking process to adopt those into our rules.
So it sounds like, in essence, what you're saying is the statutory authority to do these, whatever provides for a smooth solution, is what we would see proposed by the PUC in the coming session.
That would be our hope, yes.
Thank you very much.
Senator Bray?
So I would, with all that, and thank you for explaining and filling in, and thank you to council for helping us, I think, honor our obligations to not delegate with, not over delegate with inadequate direction. So I would move, pending further discussion, I would move that we approve Rule 22P10, Rule 2000 Rules of Practice, with a proposed modification submitted by the Vermont Public Utility Commission in correspondence from Mr. Landis Marinello, dated October 12th, 2022.
We have a motion from Senator Bray to approve Rule 22P10 as amended. Need more discussion? All those in favor say aye. Aye. Those opposed? Nay? Okay. Thank you.
Thank you.
Okay, next on our, we have some committee, a couple of items for committee discussion. Want to take them in order? Okay. First one is a presentation from Pledge Council on Administrative Procedure Act and failure to adopt the rule. Apparently, it was a request from the chair to have a discussion around this issue.
So I sent out a one-page document attached to my summary email. Charlene has a copy of my email on the table if you don't have it. But if you pick up it says Charlene Dindo at the top, this will be probably the third to last page. So it's this one page. Requested it at the last meeting, and I think this was kind of a carryover topic of conversation from what the committee saw in terms of the chart on rulemaking authority, and that being something that Ledge Council is going to prepare going forward, is what really can LCAR do or the public do if we're in a position where an agency has been told to adopt a rule or has been told that they can adopt a rule and then they didn't do it, either by a date that was put in session law or a date that was put in statute, or they were told you shall do something and there wasn't a date. And this is limited in terms of what I put in this sheet, just to what is in the Administrative Procedure Act and LCAR's rules of procedure, which don't address it, so it's not included here. But some of this is really going to be a government accountability conversation in terms of, is the legislative branch giving direction that the executive branch is then following? And it could be that if this is something that's of interest to you after I talk about what's in the APA, then maybe that these are conversations to have with your colleagues on the Government Accountability Committee or on the Government Operations Committee. So in general, LCAR has the statutory authority under the APA to do a few things. It can object to final proposed rules. That's when you have a rule here, if it's got one of the P numbers. It can object to emergency rules. That's when there's the E number. And it can object to existing rules if it chooses to take it up. But then there are only those limited grounds that LCAR can object. And that's why you're always focused on things like statutory authority, legislative intent for an emergency rule, there's that imminent threat to public health, safety, and welfare, and then the contents of your economic impact statement and the environmental impact statement. So LCAR can object on limited grounds to those different types of rules. LCAR can hold hearings on proposed and previously adopted rules. If you think back about a year, you had a hearing on some housing rules that maybe were a rule, maybe weren't a rule, but you can choose to have a hearing on proposed and previously adopted rules. You can request that standing committees of the General Assembly review certain matters within the standing committee's jurisdiction. That's what we're going to be doing in just a little bit when you send those letters based on a review of a rule, and there's something that you, LCAR, don't have the jurisdiction or the authority to deal with, but another committee does. And you can request that any agency initiate rulemaking to adopt an existing practice or procedure. And that's not the same thing as requiring the adoption of a rule, because you're requiring them to initiate something, and that's related to there being an existing practice or procedure, and those are defined in the APA. And a lot of what is important there is that it's not a rule that's been adopted through formal rulemaking. And finally, LCAR can request the periodic review of certain existing rules. So a lot of LCAR's authority is tied to there being a rule or there being a proposed rule, not to the creation of a rule. An agency under the APA is required to initiate rulemaking and adopt rules when directed to by law. So if there is a session law or if there is a statute that says you agency shall adopt a rule, agency is required to do it. But LCAR does not have the statutory authority under the APA to then require that the rule be adopted. So I think that's the key takeaway here is General Assembly tells the adopting agency make a rule. LCAR is then limited in its ability to kind of be the enforcer of that. But you, LCAR, are in a position, and you're going to be in that position more so going forward now that you're going to have your chart of new and amended rulemaking, to keep tabs on it and then have the ability to talk to your colleagues on the committees of jurisdiction that could really delve into it more in committee. And then in terms of the public, any person, so that would include any member of the public, can submit a written request to an agency asking the agency to adopt, amend, or repeal a procedure or a rule, or to adopt a guidance document as a rule. And then under the APA, the agency needs to, within 30 days after receiving that request, initiate rulemaking proceedings, adopt, amend, or repeal the procedure, or deny the request and give a reason in writing. So the public does have the authority, the ability under the APA to reach out to agencies in that limited instance. And then any agency is required to initiate rulemaking to adopt an existing practice or procedure when requested by 25 or more persons. So they would need to initiate it there. So I think your takeaways are going to be LCAR is very powerful in terms of its ability to object to things that are coming before it, but there is a little bit of that sort of division of power and expectation between your branches of government when the General Assembly is saying executive branch do X, Y, Z, and then whether or not the executive branch does do X, Y, Z.
Question. In this last part here, an agency is required to initiate rulemaking to adopt an existing practice or procedure. So the public only really can sort of say, we want to put this into a different category, right? We want to make rulemaking. They can't ask to develop a brand new rule.
Let's make sure I got that right. So they would have that authority to do it, but it's under a different part of the APA. So that's under 806A, the first paragraph. A person may submit a written request to an agency asking the agency to adopt, amend, or repeal a procedure or rule. So you could say, I request that you adopt rule XYZ. Then you're still going to need, and this might come into play in terms of the denial that comes from the agency, let's say a person says, I want you to adopt a rule on this particular issue, and the General Assembly has not given the agency the authority, the statutory authority to adopt that rule, the agency can't then go and do it. Because, and this is getting back to what Senator Gray was asking about with the PUC, with the delegation of powers, in that the General Assembly has to give the executive branch the power to do something through rule, because rules have the full force and effect of law. And it's the General Assembly that creates the law, not the executive branch. Does that clear that up?
Not entirely.
Okay.
I'm seeing two different things here, right?
Yes.
The first part here is an individual asking for something to take place, and the agency can respond to it in a number of different ways. The second part of that is if 25 or more persons want something to happen, the agency has to start doing something. But it only applies to existing practice or procedures, not the adoption of a brand new rule.
You got it.
Okay. Got it.
And then we're going to then look at the definitions in the APA as to what is a practice, a procedure, and a rule. And then you're always going to need to remember there is that rule is a bigger thing because it has the full force and effect of law if it's properly adopted. So it's more like a statute at that point.
What? Oh, I'm sorry. Senator Lyons.
Question, what, if any, authority do we have to initiate legal action?
So there is nothing under the APA. I would suggest, and I can certainly reach out to my colleagues in Ledge Council, that that's more of a government operations question. I know that Tucker has told me about, and I should have written the statute down and come more prepared, that there is language in Title 13 that can basically create a cause of action if the executive branch isn't doing what it's supposed to do. But I will get you being all of LCAR, what that statute site is. I don't think Tucker thinks it has ever been utilized.
But it would extend to LCAR through that statute?
Not LCAR as an entity. And there's nothing in the APA that addresses legal recourse there for failing to adopt a rule.
Okay. Thank you.
Mr. Chair.
Senator Bright.
Inspector Cooper, can you remind me, I don't have the APA in front of me. So LCAR does have the ability to have hearings, correct? And
Yes.
So we can inquire about things, but it's not necessarily that we're initiating or causing a rulemaking to be initiated. It's just like investigatory.
Yep, you can have hearings on existing or proposed rules, and then under LCAR's rules of procedure, you can basically take up anything so long as the majority of the committee wants to take it up. So you could have a hearing, you could take testimony, you could then send a letter to committees of jurisdiction.
Okay. And then the second question I have is, one of the things I'm not always sure that the legislature does with sufficient clarity is when we delegate authority by requesting a rulemaking, how do you judge the phrase, I don't know if it's a term of art or not, but that we delegate authority with adequate direction? And sometimes I think our direction is rather vague and maybe overly permissive. And is there any check on the legislature, how do we describe our obligation to provide adequate direction? How do we define adequate direction? Sort of how do we hold our own feet to the fire in terms of not letting something, giving away too much without enough specificity to what we're asking to be done?
Yeah, I think you hit the nail on the head in a lot of legislating. It's sort of a balance of how many details do we put in. When you are dealing with the delegation piece, there is the Constitution that says the General Assembly makes the laws.
Right.
So you will see, and some of it is just the nature of how laws are enacted, very, very vague, or not vague, but very undescriptive language in statute saying, and the agency shall adopt rules that deal with this chapter of law pursuant to the APA. And then on the other hand, you'll have something that's very prescriptive that says you're going to adopt a rule that makes this change, that really gets to what the General Assembly's intent is. And while that is something that comes up in the authority, does the agency have the authority to do what it is that they're trying to do through rule? This comes up in the federal government quite a bit too. There's also the legislative intent piece. And some of that, is coming up now with your discussion around the transitional housing rule and what is the General Assembly's intent with a specific rule or with general rulemaking authority. So yes, it is a struggle that I think you're going to continue to have, and maybe it's something that more attention should be placed on when rulemaking authority is being put into statute. And to sort of go back to you're going to have a tool, you're now going to have something that's prepared at the end of each that will give a snapshot of the details that are going into statute or session law for new and amended rulemaking. And you'll hopefully be able to see if there is that sufficient detail. And I think you would be in a position where if the adopting agency didn't feel like they had either the authority they were looking for or the detail that they needed, that would come through the process in committee.
Okay. I don't know how we would do this, but sometimes I felt as though it would be helpful for LCAR to speak to the legislature more broadly or to chairs, or I don't know, because who we would address it to. But because of my LCAR experience, I know that in our committee, when we invoke rulemaking for years now, we've put in shall commence by, be completed by. So we'll put in start and finish dates as opposed to just invoking it without any kind of schedule. And then this past year, when we invoked, we added a section on legislative intent explicitly in the bill. It's session law, but it's for the rulemaking, because I could imagine that rule landing in this group and everyone saying, well, what did they really mean? And so I figured better spell it out, because if we're going to say it meets legislative intent or not, what's the test? And so we spelled that out. And I don't know that that would be good practice everywhere, but I'm just thinking sometimes our job is made harder because the invocation of rulemaking is vague, undated, and maybe even overly permissive.
Yeah, and I don't think this is a great answer, but it's the answer I'm going to give. Some of that is going to be a balancing when you are in the process of enacting law, because there could be that instance where the General Assembly really knows what it's looking for, when it's looking for it by. They just don't have the expertise to craft rules on water quality. Or there could be another instance where there's something new. I'm going to use automated vehicles as my example there. That is permissive language that says the Agency of Transportation may adopt rules on automated vehicles. And I remember this because it was something that Senator McDonald asked about in Senate, asked members of Senate Transportation about it. And the agency's response was, well, we don't yet know if there needs to be rules on it, but there might need to be rules on it. So that was an instance where there was a decision made at the recommendation of the agency to use a may as opposed to a shall. So, and you guys know this so well, one size shoe doesn't fit in every instance, and what might make so much sense in one instance won't necessarily make sense in another. It's great that you're thinking about it.
Thank you.
May I add a comment?
Alliance?
I don't want to interrupt Senator Bray if he was going to say something additional.
All done. Thank you.
All right. So, yes. So, I mean, this brings to mind the information we received from the auditor's office, from the assistant auditor, Ash. And then it also brings to mind the work that in the past, the Secretary of State, as well as government operations committees, have done on LCAR, sort of how we operate, but also how committees function. And I'm just wondering, given the breadth of what we're talking about, some of this is work that we can do and make recommendations to committees of jurisdiction. Some of it is work that perhaps the Secretary of State's office and or our GovOps committees can weigh in on. I think it's a pretty broad discussion, and so it just even to the extent of saying, if you have new rules coming up, you may a new electric vehicles and rules regarding them, that you would want to use the word may. Some educational process, I think, for committee chairs or others. So this is a pretty big issue. I just wanted to say I do think it's important. And I think it's important that we have committees aware of establishing appropriate guidelines whenever rules are written into policy documents.
Yeah, if I were to boil all that noise, long conversation down from my point of view, if I were to make a proposal, it'd be that LCAR, sort of formally discuss with Ledge Council some sort of presentation, maybe one at the beginning of the biennium, so that we all launch with a clearer understanding, as we're really thinking of the non-LCAR members becoming more aware of what LCAR's obligations are and how they can, as well as their own legislative obligations, to delegate with adequate direction. It will help LCAR, it will help the legislature. And I had proposed this totally nerdish seminar more than once in the past, and no one wanted to sign up nor create the program. So it might not get much further this time either, but.
How can we write a one-pager that would cover all of that?
Probably can't, but it's an interesting idea. I mean, I don't know about doing a seminar where you want people to show up, but just make information available about the process and just make sure that people are aware where they can look at this. Certainly be germane to leadership of all committees, maybe not every committee member, but certainly to your chair, vice chair, ranking member, kind of thing.
You could probably do I'm sorry.
No, go ahead.
You could probably do a very short, succinct presentation to the committee chairs when they meet. The committee chairs meet on a regular basis in the House anyway.
Yes.
And probably in 10 minutes, you could convey the heart of what we've been discussing here. Because you're really saying, just remember to mentally check these boxes and make sure you have thought through which instance, which level we're looking for.
Yeah.
But I do think chair, vice chair, and ranking member would be very important.
Yeah, and I think it's more to make use of your legislative council. In other words, no deterrent to them to say, should we be addressing this in this piece of in our bill writing for our legislative work? So, okay, yeah, it's a good idea. You taking this on?
If I am invited, along with some of my colleagues, to talk to chairs, vice chairs, ranking members, et cetera, I think we certainly could make ourselves available. And I am always happy to talk about the APA. I think it's interesting.
Representative Fagan.
Thank you. From my perspective as a legislator, I've seen it over the years. And when you're talking about legislation that gets passed, rulemaking and so on, you can have agency heads, administration sitting in front of you saying that it can't happen in that time frame, can't happen with that amount of money. And I think that's crucial in what we do as well. Now, you can say that they may be stalling, that's not a position or a bill that they may not want to do. But on the other hand, when they come back and say they need an additional $1 million to complete a particular, legislative intent that we had done, that's not good.
Yeah.
Senator Bray and then.
Yeah, so I really appreciate you pointing that out. I mean, for anything coming through our committee, my constant refrain is, if we're asking for something that you cannot do with your current resources, please tell us, because our success depends on your success. So let's not set ourselves up for failure, and then I think where we get into something a little harder is sometimes that operating area does not feel free to ask for additional resources to implement something because of, sort of whatever, preferences around staffing levels, for instance. But I think it's always good to make that explicit that we don't ask, I hope we never ask for something that we're not willing to support. But I think that happens. For instance, the Environmental Justice Bill left our committee with, I think, about $3 million of funding. I think it left the end of the year with something like $700,000 of funding. And there was not a big pruning back of the obligations of the bill to meet a reduced budget. So to me, we're setting an operating area up for there is a phase in. So sort of the wobble room was, well, we'll phase into it, but I'm a little concerned that we may not revisit adequate funding.
Representative Wood.
And I wanted to add to that expanded list of leadership to be educated. It could be open to everybody in the General Assembly and then, but highly urged or recommended for leadership. So everybody has a chance to learn.
I think it's really, this is such a good idea because so many folks in the legislature have no clue about what is involved in LCAR and the importance of the work that we do with respect to the link between policy and implementation. So I think it's important that we go forward and Anthea can provide us with super information to share.
I can tell you that
Please,
my starting
please.
will be a pruned back version of the Welcome to LCAR memorandum that goes out to all new members of LCAR. So I think it would be the Cliff's Notes version of that.
Sounds good.
And a break.
I'm just thinking aloud with you too. I would also know, like on the House side, you have 11 of 14 committees will have new chairs. And I don't know about the Senate. Overall, there's like 1/3 turnover for the entire General Assembly. So there's a lot of change going on. So in a way, it's kind of an ideal time to, have that part of our curriculum as orienting the next General Assembly.
Okay. I think we move on at this point.
So you've got
Thank you.
you have two memos to review. Again, they're in that same packet. One is on the Vermont water quality standards, and then one is on the cable television. So these were the memos that Ledge Council was directed to prepare at your last meeting. As a reminder, to send this, you need to have the majority vote of LCAR, so it would need to be all 5 of you that are present, and then these will get sent by Charlene on LCAR's behalf. In terms of the rule on cable, you are asking the House Committee on Energy and Technology and the Senate Committee on Finance to review any potential issues related to regulation of cable television by the PUC and any unintended consequences of the regulation of cable television by the PUC that could affect the expansion of broadband in Vermont. And then for the water quality standards, these are the 3. It was 2 topics, and then you added 1 to it and expanded the committees. That was the request of one of the witnesses you had. So you will be sending requests to the House committees on human services and on natural resources, fish and wildlife, and the Senate committees on health and welfare and on natural resources and energy to review 1 or more. And I did 1 or more because of the sort of split in jurisdiction. The monitoring for pesticides and PFAS in the waters of Vermont, the consideration of preventative measures to limit the levels of pesticides and PFAS in the waters of Vermont, and ways to improve the process for reclassifying the waters of Vermont. So hopefully I captured what the committee intended with your requests from the last meeting, and we can certainly change language if any of you think that it needs to be changed. And you will need to take votes on these.
Any discussion?
Thank you. I think they look great. And we in health and welfare will be diving right into the reclassification piece. That's a frivolous joke.
I'm laughing behind the desk.
You made my ears perk up.
I know.
Why don't
Thank
we
you.
take- Yeah, thank you, Senator Lyons. Let's take the cable television one first. Any additional conversation, discussion?
I think it captures it.
Have a motion?
Acceptance of the, I move that we send the letter as written.
Okay. We have a
That's the
motion from
memo.
Representative Bongartz to accept the memorandum related to Rule 8.000 cable television. Any more discussion? All those in favor say aye.
Aye.
Aye. Opposed? Thank you. Next one is the Vermont Water Quality Standards. Any additional discussion? Senator Bray?
I would just move approval. Thank you, Ms. Dexter Cooper, and I would move that we approve this letter to the Committees of Jurisdiction regarding Vermont water quality standards.
We have a motion from Senator Bray to approve the memorandum related to Vermont water quality standards. Any discussion? All those in favor? Aye. Opposed? Thank you. All right. Any new business or? Senator Bray?
We're lacking our traditional adjourner motion person. So I would move that if there's no further business for the committee, that we adjourn.
Can I make one comment, please?
Okay, Senator Lyons?
Before you vote? I just want to say that my thoughts are with Senator McDonald, and I know that he is improving rapidly and is looking forward to returning to his work on LCAR and in the Senate. So I just wanted to acknowledge Senator McDonald.
Thank you, Senator Lyons. Motion to adjourn. All those in favor? Aye. No vote. Okay.
So now,
Thanks, everybody. Appreciate it.
thanks.
Thank you.
So now I know that I have a